Thank you. Thank you for this opportunity to speak. Thank you for that you have sent me an invitation for the event. Thank you that I have heard foreign experts on this matter. In my remarks, I would like to draw the attention to item 4 of the methodological recommendation, where it reads about the principles of applying fines. With great pleasure, I have heard the presentation of honored Mr. Russell Duffel, who does draw attention to 3 principles in applying laws on economic competition. First, whether and in what way fines will facilitate the competitive environment in future. First, as means of curbing of and third, institution does restitution ways to persons who experience losses. But this the institute of responsibility is the punitive function. Second function, that's the institution function, and third function is the compensatory function. I would like to point out that implementation of this function just requires its own mechanisms of application, which is the institute of responsibility. The second version, which has been provided by honored Servant Lefrand, as for that the European Commission has provided some discretion powers, as it is actually happened in our country, according to Article 52 of the law on the protection of the. But from his remarks, I understand that first, each case is only individual that can be revised by court by applying the other provisions of the laws in effect, including such principles as the principle of the sound mindedness and substantiation and other principles that have been instituted by relevant legislative acts of the European law, and relevant fines in respect of any court that may be decreased. In our country, it isn't possible. In our situation, the court verifies where the case has been a reality, and whether it complies with the provisions of the law, and just whether this resolution made just complies with the legislation of Ukraine. Having the opportunity of the presence of the Mrs. People's Deputy, well, what can we do about? How can we change the present laws by making more details to that? The second remark will relate to the technical component. I would like to say that a fine is such as a law norm, as by its essence and by form, it has been established by relevant provision of the law. At present, I don't know, we're discussing approaches to applying the responsibility. Can we explain approaches actually by the subject matter? It's not explanation on the application of Article 52, it's the discussion of approaches to applying relevant means of responsibility provided under the law, which the AMCU cannot change through any legislation. Introducing such a category as a fine is beyond the scopes of the powers of the AMCU and contradicts Article 52 itself. When, as a practitioner lawyer, would like to slow down any case, then I would right away, after passing a resolution, according to this explanation, would appeal such explanation on the whole, as such that introduce legal categories that are not provided by the laws, by the law of Ukraine on protection of in particular Article 52, does allegedly to the explanations on which relevant fines are to be applied. Therefore, in my opinion, it will be reasonable not to restrict powers of the Anti-Monopoly Committee of Ukraine, and I would like to point out that the conditions of the market in different industries are different from well-established competition to monopoly, which even provides for the use of punitive fines. You cannot just establish for all industries and of the economy or the sectors of the economy all just flat fund. Probably we need to devise some methodological recommendation under which to develop some criteria and what objectives government agents to withstand in cases as it is specified in Article 4 of this recommendation, and to supplement these explanations, which are like the criteria of Mr. Damstov. As for the influence, I would like to point out that based on annual reports of the Anti-Monopoly Committee, huge amounts of sums are indicated, but when in the report how much has been got by the state, these indicators are not matched well. But imposing fines by the NAMC, the company is simply disappearing. They do not pay fines, but as a result of that, such application of the current laws makes only damage. Understand, the Soviet tradition is based on a punitive function, based on responsibility, and as for the application, it's easier. So it is 30% and or 45%. It is the reason I applied it. What will happen after I apply it? Then it doesn't touch to me. Therefore, it's a wrongful approach, and I think the Anti-Monopoly Committee should be basing its activity on functional approaches to ensure competition. Because each annual report of the AMCU of the previous convocation starts with that, just to what extent the monopolization in the economic sector is increased, and step over to the work, because the fines provided by Article 52 is too wide. It provides too huge powers, and what you use these powers is dependent on the leadership and on the tasks put by the AMCU and by the leadership of the country. Thanks.